an affidavit can become a declaration when you go public with it. You don't, but you continue to call it an affidavit because that's what it originally was. So that's the technical difference between them. But in practical terms, it absolutely makes no difference whatsoever whether you call it an affidavit or declaration. It's going to be the same thing. Okay? Now, an affidavit or declaration has certain forms. Now, I want you to know that the volume of lawsuits is so great in California that the Council on Judicial Performance, I guess it is, or is that what it's called, or the Judicial Council, they're trying to standardize some of these forms. So you have forms for complaints, you have forms for summons, you have forms, there's all kinds of forms. They got hundreds of forms. Some of the forms are mandatory. Now, in theory, if you're sovereign, you open your own court, you don't have to pay any attention to that. But the fact of the matter is that these forms exist, frankly, because these problems pop up over and over again. They're familiar with them. And so if you use their forms, you're now giving something that they're familiar with, and it becomes easier for them to either agree or disagree with you. Yes?
I have a question. Let's say you have two declarations that are with this attorney that I'm speaking of, and the declarations are untrue, and there are witnesses to refute those declarations. What happens?
Their witnesses refute the declarations? Or why don't you get declarations from their witnesses where they're refuting it?
The witnesses did do the declarations, and the attorneys never used them. They said that that's going to come later.
Well, do you have copies of the declarations?
Yes.
Okay.
And notarized.
And you're saying that those witnesses are refuting those?
No. The witnesses are refuting the declarations because they were actually there, because all of it is based on hearsay. But they were actually physically there.
Yeah, but they made a declaration saying what they saw, right?
Let's say the plaintiff's attorney's witnesses made two declarations.
Sure.
Then I have two witnesses that were physically there. And made their declarations to refute what these other declarations were.
Okay, so you have a conflict of evidence.
Right.
All right, well, you see, when it comes to judgment time, the tribunal, whoever that may be, is going to have to decide which witness is telling the truth. That's a normal problem in any court proceeding.
A conflict of evidence?
Yeah. Well, if you want to call it that, but, I'm speaking plain English now. You got, here's a piece of evidence, here's a piece of evidence, and they conflict. Well, now you got to decide which one's the truth and which one's the lie. That's normal. That's what courts are for. So yeah, you got a problem. So you got to if you've got two witnesses that were physically there, and you got two witnesses saying that I heard something, well then obviously direct observation takes precedence over hearsay. And hearsay is not usable anyway unless the person is making a dying statement. That's the only time hearsay is good.
What is a dying statement?
Well, somebody's dying. Somebody gets shot, and he says, "Joe shot me," and then he dies. Okay, and nobody saw it, but they did hear the dying person say it. And since he's dead, they will accept that hearsay. When somebody says, "I heard him say Joe killed him," that is acceptable in court. That's the only time hearsay is acceptable. I think it's the only time. Okay? Alright, so an affidavit. So every motion must have an affidavit or a declaration of just the facts. Okay? Just the facts. Okay. Every declaration must be supported by facts. Okay? Not opinions. What are facts? Okay, you ever heard of who, what, where, when, why, and how? Okay. Facts consist of who, what, where, when, how, but not why. Okay, why is opinion. So, but all the others are factual. Who, what, where, when, why, not why, and how. Okay? That's the factual thing. Also, facts must include 6 senses. Facts must include 6 senses: hearing, seeing, feeling, smelling. What's the other one? Was it touching? Well, that's feeling. What is it? No, it isn't. No. Yeah, hearing, smelling, feeling, seeing, tasting. That's the 5. The 6th one is what you were thinking, how it impacted your mind. You can testify to your state of mind. Okay, that's the 6th one. In other words, you can say, I was scared, or I was intimidated. That you can say. You cannot say that he was intimidated, but you can say, I was intimidated.
Could you say, he appeared to be intimidated?
No, but you can say, he appeared to you to be intimidated. Let's say you're standing outside a wall. There's 2 people inside. One of them murders the other one. And you hear the one who's doing the killing, you hear him talking, and you recognize his voice. You can be a witness to the murder because that involved your hearing. It's a fact. That was his voice. I know his voice. I recognize it. You can testify to that in court because it involves the 5 senses. So you don't have to see it. You see, most people think that to be a witness you have to see something. It's not true. To be a witness you have to see it, hear it, smell it, feel it, something. One of the 5 senses, or you testify to the impact it had on you, on your mind. Okay, so that's what a fact is. Alright, now, again, same format. Okay? You can get standard forms from the Judicial Council for affidavits. They have them. So, like I said, some of the forms are mandatory, some of them are optional. I like using my forms because, frankly, I'm comfortable with them. But I have to tell you one thing about these forms. That is that the forms have a lot of boxes and check marks and, things that are common to many cases. I want to warn you that if you have a certain issue and you leave something out that's critical to the issue and you left it out because it was not on the form, the Judicial Council wants you to use these forms, but they take no responsibility for making sure they're complete and correct. All right? So it's up to you to make sure that every element is covered. Again, I recommend Matthew Bender's books, Forms of Pleading and Practice and Points and Authorities. So you got an issue, go through their checklist. They're great. Yes, ma'am.
Again, going back to the declaration for affidavit, this particular attorney gets the declarations, but phrases everything that these people are saying in the context that would make it in his favor. Or
sounds like he's a good strategist.
Right.
What stops you from doing the same thing?
Nothing.
Okay. You're entitled to put your best foot forward. That's not considered bad ethics to make yourself look good as long as you don't lie. Now, if it becomes an actual lie...
It's an actual lie.
Well, then you have a basis for sanctions, because attorneys are not supposed to encourage their clients to lie, okay? And if you have evidence that they encouraged it, that's a place for sanctions. Make a motion for sanctions, go to Matthew Bender and look up sanctions. Sure, anybody pulls a fraud on the court, and even if you don't find a specific rule, you can make up a rule.
I'll give you a for instance.
You've expressed your case, right?
For instance, I'm asking you, you just came into the neighborhood. You just moved in next door to me.
Yeah, look, I don't want to get into the specifics of cases, okay? We're staying with emotions.
Right.
But I'm telling you that if you got an issue with somebody lying on it, you ask for sanctions.
Okay.
That's the answer. Or you get a court you get it thrown out. You make a motion to have that particular thing thrown out because it's an obvious lie.
Is Matthew Bender on the internet?
I don't know if it is or not, but I do know you can go to the public library and it's there for free. They have the books and they have it on CD. The CDs you cannot borrow, but what I did is I went there and I copied sections onto a diskette And that's all. It's real easy. Anyway, so here is, in this case, I was applying for substitution of plaintiff. Okay? So this is the affidavit, the facts. Nothing but the facts, ma'am. I am William R. Thornton. I'm the petitioner in this case. I have personal knowledge of the following facts and am competent to testify as the truth of these facts, if called a witness. Okay? That's boilerplate. You want that on every affidavit that you have. That first paragraph, the first two paragraphs, right there, are standard. You put it on there. Now, you all have heard about getting your affidavits notarized, right? Well, you don't have to get them notarized. If you put onto your affidavit statement what you see there, and you put also at the end, I declare in the penalty appropriate that the foregoing is true and correct, and that this declaration was executed in such and such a city on such and such a date. The 3 paragraphs, the first 2 and the last one, if you do that, you do not have it notarized. Okay? It's equivalent to having it notarized. So, some people like having it notarized. You know, understand that court process, a lot of it is intimidation. A lot of it is strategy. So, if you think that the enemy would be somehow psychologically impacted because you got a notary's certificate on there or something like that, well, then you do it. Because this court process is primarily law, but secondarily, it's psychological warfare. Okay? And I think a lot of you know have experienced the impact of that. Here's an example of facts. On December 25th, 1984, Christmas Day, William C. Thornton, plaintiff, passed away. The certificate of death is attached as Exhibit B and is incorporated by reference as though fully stated herein. That's another thing that'll save you a lot of writing. That little phrase, incorporated by reference as though fully stated herein. When you do that, you have an attachment, you put that in there, absolutely is the same as if you wrote it all out. Okay? I use that phrase a lot. Incorporated by reference as though fully stated herein. That's the phrase. You put that in there, you can bring in stuff without making your motion large. Most courts have about a 15-page limitation on your motions. Okay? You try to keep your motions down to 15 pages. Sometimes it's difficult to do. Or your affidavits, or whatever. Actually, the affidavits can be as long as necessary if they are relevant facts. It's the briefs that you want to keep down to 15 pages. But if you need more, you can always make a motion to the court, again a motion, okay, with all the same stuff, same idea. But you can ask the court for permission to have a more pages. If you have a complex case, you can do that.
Why are your exhibits reversed?
Well, because I labeled them first and I used them second. It doesn't matter. Doesn't matter. See, I'm asking the court to allow me to substitute in as the new plaintiff. So it's relevant to the motion when we say that the plaintiff died, right? I mean, after all, I want to be substituted in, right? So that's what it is. And here's the proof. Here's the certificate of death. Okay. Before the plaintiff passed away, he granted power of attorney to me to resolve the conflict. The power of attorney is attached as Exhibit A and is incorporated by reference as so fully stated herein. I am an heir to William C. Thornton. I'm also executor of his estate. And I had a will that made me that, okay? I have been continuously and intimately involved in the case at all times. My interests have been identical to those of William C. Thornton. I have been likewise injured by the activities of the other parties in this case. In substance, there is no differences among the interests of William C. Thornton, his estate, and those of myself. Those are the factual things. A little bit conclusionary when I said there are no differences. See, that's a conclusion. That's not really acceptable. But what is a fact is that I have been continuously and intimately involved in this case at all times. My interests have been identical to those of William C. Thornton, and so forth. In substance, so I made a conclusionary statement. In substance, there are no differences and so forth. but the conclusion was made after I presented the supporting evidence. Okay? You don't make conclusionary statements all by themselves on an affidavit. If you are going to throw one in, make sure you built the base first with facts before you make it. Then it's okay. But you always want to put the facts in so that the reader will come to that same conclusion at the same time that you present the conclusion. So there you have the affidavit. That's all there is to it. It's in court format. Okay, has the 28 lines down the side of the page. It has the little label at the bottom, declaration of, in support of application, so that they can see what it is. Has a page numbering, and so forth. So, okay, makes sense?
Yes.
I'm keeping up. So now we have a separate affidavit.
Say, Bill.
Yes, sir.
You asked the magistrate if you go over 15 pages, or you asked the court yourself? I'm a little confused because you use the words interchangeably.
Well, I'm using it interchangeable. All of this stuff applies equally to the normal equity courts, just as it does in the common law courts.
So
it's the same thing, but there is an advantage to being the decision maker.
Why did you go 16 pages deliberately on Aurora's? And you said it did it deliberately. Now, why was that?
Oh, no, I didn't use pages. I didn't generate pages on purpose, no. I don't know what I was saying deliberately, but it wasn't that.
Oh, I thought you said if it's 15, why did you go 16?
Well, because it required it.
Who'd you ask, yourself?
Nobody. Nobody. I just assumed they'd accept it because it was only one page.
Okay, all right.
You can. It's a rule, but I mean, they face reality too.
Yeah, but the rule is if you have to ask, who are you asking it?
You're asking the court.
And who is the court?
Well, if you're the court, you can turn around and prove it.
So if you're asking yourself,
basically you just have to give them notice that you're going over. Wouldn't that be?
Well, yeah, I mean, the other side gets a chance to be heard before you move the court. Before you actually issue the orders, you ought to hear from all points of view.
So you would basically say 16 pages are needed.
Yeah, if I were actually to go formal and ask the court for permission to have 16 pages instead of 15 pages, sure. And then if I'm the tribunal, I'd turn around and either approve or disapprove. Probably would approve.
Okay, that's the clarification. Thank you.
But, you have to have an element of neutrality when you put on the tribunal hat. See, I mean, it's like in this one case, in the example case where I went and I showed you that second paragraph, about the people in the court of record. In that case, we made an accusation against the judge for contempt of court. We also made an accusation against the clerk because they were in cahoots with each other. Okay? So when wearing the plaintiff's hat, we were hitting real hard. We were throwing all the punches. We're saying this guy talked to this guy, and we want the court, and we're yelling for contempt of court. But as soon as we switched hats, and now we became tribunal, we ultimately decided that the clerk was subject to undue influence from the judge, and that the clerk really couldn't be held responsible. Okay? So here we are on the plaintiff's side, we're aggressive, we're out to attack everybody, but then when we become the judge, we move to the center, we say, well, wait a minute, what's the story here, What's really reasonable? And it takes some psychological rearrangement, because you're in a mindset when you're writing your complaint, when you're beefing about something. But then you have to, if you are indeed going to be the sovereign of the court, and indeed the tribunal of the court, you absolutely must rearrange your attitudes, become neutral, pretend that the person you're judging is not you anymore, but someone else. How would you do if it were someone else that came to you? So you really, really should do that. And if you do that, you'll get a lot of respect from the people. If you just go in and slash and burn because you've got the advantage of being the sovereign, believe me, it's not going to work. Because you see, the common law reaches everywhere. And when I say everywhere, I mean, look, common law ultimately comes down to a very simple definition. It's the opinion of your public. Okay? Public opinion. And part of your public is the clerks, the judges, the sheriffs, the marshals, as well as the newspaper reporters if they're looking at your case, as well as your friends or whatever. Okay? That's public opinion. Well, when you put on your tribunal hat and they're reading through your reasoning process, your logical processes, you want them to come away with the opinion, hey, you were really being fair with these people. You're really coming to a decision. These decisions that we make, whenever I put on the tribunal hat, all of a sudden I become a very kind person. I don't allow this person the claimant to get all he wants, including myself as a claimant. So you're thrashing away as a plaintiff. Everybody understands that. Yeah, you're going after him. Okay, you've got a lot of resentment, a lot of hurt and so forth. But when you're the tribunal, you've got to throw out all those emotions. You've got to be absolutely neutral. And the idea, the number one function of all judges is status quo. I don't know if you've noticed that. But it's status quo. Whatever is. They're not going to let you hit back, even when they should. Okay? So there's a reason why 98% or 99% of all cases against corporations are lost by the people doing the suing. And it's that statistic is because judges go for status quo. Whatever it is, their job is to settle things, not to be fair. So I do the same thing because, frankly, in my own personal philosophy, I see merit in keeping things settled. There's nothing, you don't want to be continuing the fight. You want to settle the fight. That's why it was when we this guy that got hit on the bicycle, he wanted to go for more than $2 million. I said, no, hold off. $2 million's enough. Got $100,000 in medical bills, and you got a lot of impact on your future earnings and so forth, but $2 million will cover you. Okay, don't go for more. And eventually he saw the light and stayed with $2 million. You know, but you see these billion-dollar lawsuits, and the people who ask for that $1 billion, I know they're genuinely hurt. They're angry. But when you put on that tribunal hat, you want to be kind of emulate the judges in some degree that it is correct. But at least you don't have to be unjust when you do it. You know, get back to reality. And sometimes if you don't know what to sue for, look at comparative cases and see what they sued for. There's plenty of judgments that did win. When somebody goes to jail on a false arrest, I say, well, lawsuits that I've seen in the past seem to run about $50,000 a day for false arrest. Okay? Seems like a reasonable figure. Well, in one case, a guy got $1.25 million a day. That was in Florida. But, you know, that's unusual. What's usual? I know when you're in jail, you feel like $1 billion a day would be fair. You just got to use some sense and conform in, because remember, I repeat this over and over again, it is the custom and usage that counts. That's what common law is about. Public opinion. Put on a good show and do what other people seem reasonable, and you have a better chance of being successful in getting cooperation. I don't want the sheriff to go out and telephone first telling the person that he's coming out to collect the bill. I want that sheriff to believe in my cause. And he's not going to. He's not going to go out and collect $1 billion from a guy who owns a one-bedroom house. You understand what I'm saying? Okay, well, anyway, so this is the declaration. And you'll notice that in the caption, it says, Declaration of William R. Thornton. All right? And it says, in support of application for substitution of plaintiff. So the original motion was application for substitution of plaintiff. That was the name. So I copy that name, and then I say that it's a declaration in support of that. That way, when the person picks up the paper, he looks at the title, it gives him an idea of what the point of view is. Again, you're making it easy for the reader. Use a caption. Now, another word about this caption over here. You'll notice that we have the full list of defendants stated. You don't have to do that. Whoever is the first one on the list, you put, like here it would be Corbett E. Britton. You could say et al. E.T. space AL period. ET means and AL period, I forget what the Latin word is, but it means others. It's and others. Okay?
Symbol for versus, VS.
V or VS, either way.
Okay. I understood that V is more proper. Is that correct?
Not that I know of. Actually, I think VS was the original, but I guess they started saving ink. They cut it down to V.
Paper saver.
I guess, yeah. But everybody knows what it means now.
Cases with using V sometimes.
All right. Well, anyway, so that's the affidavit. Okay, so let's move on to the next item. Points and authorities. Now, points and authorities actually consist of three parts. It's the point that's being made, the supporting authority, meaning law, or maybe horn books that have some sort of well-reasoned statements in them. Could be statements out of American jurisprudence. MJur is highly respected. CalJur is highly respected. So you can quote those authorities, okay? So, and then you have the argument in support of the point. So, you see, you state your point you're being made, you state the law, basically, and then you take the entire ball of wax. That is the affidavits, the law, and you argue your case. And this is where you put your emotion in. Okay? This is where you really state your cause. It's just as if you were in front of a jury. You're trying to convince that jury why it is you're right. That's what the argument is for. This is the only place in all of the motion where you can actually make conclusionary statements legitimately. Okay? You cannot state a conclusion in an affidavit unless it's fully supported by the facts that lead up to it. You cannot state a conclusion in your authorities part of your points and authorities. You can only state your conclusion in the points and in the argument, and nowhere else. So here's an example of points and authorities. As you can see, we have the same format in the caption. And we say points and authorities in support of application for substitution of plaintiff, ex parte. If you were on the defending side, somebody was making a motion, you would call this points and authorities against the application for substitution of plaintiff. Same idea, just change a couple words. You have the normal caption on the left. You'll see that you have those three lines, lines 24 and 25. And those three lines are in all capital letters. And that's the point that you're trying to make to the court. William R. Thornton should be substituted for plaintiff William C. Thornton. That's the point I'm trying to make. So I put it there. So in your points and authorities, you have points, you have authorities and argument. Those capital letters right there are the point that you're trying to make. So now the court, or whoever reads your paper, has a clear idea what it is that you're after. Now the next part is the authority. Quote, although this section in permissive terms provides that court may allow action or proceeding to be continued by or against his representative or successor in interest, personal representative of person who has filed a suit before death has, by custom and practice, absolute right to expect and demand substitution if the cause of action on which the suit was commenced by decedent during his lifetime survives or continues. And that was Majors versus Merced County in 1962. 207 Cal 2nd, 427, 24 Cal Reporter, 610. Okay, now these sites, I guess you understand, the 207 is that's the volume number, California Appellate Court, 2nd. That's the second set that they've generated. And 427 is the page number that it's on in that particular volume. Does everybody understand that, I guess? Okay. That's how you do a cite. It's volume, what book it is, what set of books, and what page number. So that's one of the authorities that I'm citing. The settled practice is to allow substitution of the personal representative of the plaintiff on suggestion of his death and ex parte motion to allow the substitution. Campbell versus West.